Good afternoon, ladies and gentlemen, and welcome to Dublin City University. My name is Federico Fabbrini. I am the full professor of law at the School of Law and Government of DCU, and also the director of the Law Research Centre of our university. And it is my great pleasure to introduce this seminar on human rights after litigation, which is the third seminar hosted by the Law Centre in this academic year, and indeed the first one in this calendar year. For those of you who are not familiar with the Centre, this is the main platform for research in law at Dublin City University. The Centre promotes an interdisciplinary contextual analysis of the law, and we have a strong focus on European and international legal issues. As I was telling to the speakers of today's panel, for this academic year, we have chosen as a fil rouge, as a running thread for our Law Research Centre seminars, the topic of law after, using it broadly as a catch to connect various events. So earlier in the year, we hosted one seminar on data protection law after Brexit, and then another seminar on environmental law after the Glasgow Climate Change Conference. And I think we're really fortunate to have another event today entitled Human Rights Law After Litigation. And I really want to thank and acknowledge the great work that David Keane has done for putting us together this afternoon. And as you all know, David is our assistant professor of international human rights law at DCU and formerly a member of staff at Middlesex University in the United Kingdom. And David, you did a fantastic job in putting together a stellar cast of speakers who I have the pleasure of introducing today in alphabetical order, but also in the order in which effectively they will be speaking. First is Aoife Daly, who is a lecturer at the School of Law of UCC, University College Cork, and a specialist on environmental law issues as well, in fact. Then the second speaker will be Cathal Doyle, who is a senior lecturer at Middlesex University in London, where he's also the program leader for the LLM. And Cathal, thanks for being willing to step in, actually pretty short notice. We're all very grateful for that. Then David himself will be speaking, and certainly last but not least, Annapurna Waughray, who is professor of human rights law at MMU, Manchester Metropolitan University, will be concluding the panel with her own remarks. While I am myself a former and still current scholar in the field of human rights, but mostly with a focus on human rights in the European Union, I wrote a monograph called Fundamental Rights in Europe. My role today is really mostly formal. I'll be chairing, moderating, and basically keeping the time. And we have agreed with the panelists that each of them will have 12, maximum 15 minutes for their presentation, followed by a joint Q&A session. So I'd encourage all speakers to stick to the time, but I also want to anticipate to the audience that there will be the opportunity later in our webinar to participate actively by either raising your hand or sending me your questions via chat. I'm glad to see that the number of participants is increasing, so we have a good attendance today. And I obviously need to remind people that we are recording this event so as to make it available to our PhD students also afterward. So with that said, and without further ado, I think I'll stop my remarks here and immediately hand the floor to Aoife, who will begin with her presentation on human rights litigation before the UN Committee on the Right of the Child. So Aoife, the floor is yours.
Hi, everyone. Can you hear me okay?
Yes, we can.
Oh, great. I'm Aoife. I'm from University College Cork, and not long since moving from the University of Liverpool, where we have a European Children's Rights Unit. And I'm delighted to be here, and thanks so much to Dave and Co for the invitation. And it's amazing to be in such distinguished company. And I'm going to be speaking today about after litigation in relation to the climate case before the UN, well, the climate petition before the UN Committee on the Rights of the Child. So it was really a groundbreaking and fascinating petition whereby in 2019 youth activists used the instrument best tailored, or most specifically tailored to children's rights. You may have noticed, you know, even in the media, that Greta Thunberg's, her kind of profile, I suppose, made it quite prominent, and 15 other children then aged between 8 and 17 years from various nations submitted a communication to the committee under the optional protocol to the Convention on the Rights of the Child on a complaints procedure, OP3, which is relatively very new. The cases have only been coming through for about 5 years. So they argued that 5 respondent states, Argentina, Brazil, Germany, France, and Turkey, had breached their obligations under the Convention on the Rights of the Child because of the failure to tackle climate change, and they picked the 5 biggest polluters who happened to have ratified OP3, and that was the reason that those ones were identified. So they cited the right to life, the right to health, the right to Indigenous children to their own culture, and also the principle of the best interest of the child in relation to the policies that states have and the effect of those policies on climate change. And I suppose to kind of start at the end a little bit, the application was ultimately deemed inadmissible last October due to the failure to exhaust domestic remedies because the children had not gone through the domestic systems of those states. Now, the thing about that is that in despite of this determination of inadmissibility, the application was still groundbreaking in a lot of ways, even before the judgment was delivered. So I'm going to talk a little bit about that. I'm going to consider briefly the inadmissibility kind of issue, and then turn to the effects and the kind of legacy of that particular petition. So how was it groundbreaking? Well, I mean, it's in line with, there's been a real, what's called a rights turn in climate litigation, and that human rights arguments are being used to secure, you know, successes in some ways, although you can really debate about how successful in practical terms a lot of these outcomes are. But cases like the Urgenda case in the Netherlands, where rights instruments are used to make arguments about the acceptability of states' policies, and especially in the advent of the Paris Agreement that states have signed up to, has kind of left them open to challenges that they're not actually abiding by that agreement, and then tacking that onto human rights arguments. So it's a really interesting situation. And for somebody who specializes in children's rights like me, it's even more interesting because of the fact that children and youth, you know, having become so prominent in climate activism and advocacy, have become key litigators in really a lot of these cases at national level, with the Juliana case, which has actually been proceeding for even a few more years than before Greta Thunberg kind of made youth really prominent in all of this. But also now at international level as well, we have a petition, the Duarte Agostino case, going through the European, has been submitted to the European Court of Human Rights, kind of quite similar to this Committee on the Rights of the Child petition, which is called the SACHI petition. So this is kind of all unfolding and is incredibly exciting in children's rights, because groups of children like this litigating on what you could call quite a political issue of global importance is completely unprecedented. I mean, cases about children full stop are, you know, in a significant minority at international law at all. Usually they're taken by adults with kind of interest in what's going on, like parents who may have had their children taken into care unfairly and that kind of thing. So the nature of the rights issues at play in SACHI is the kind of first thing that really stands out as unusual and a key step in jurisprudence really in international human rights law generally. And even when we look at, you know, the kinds of cases that were taken under the OP3 to date, they would really be about immigration, about child protection, of course, hugely important issues, but not different at all than the primary cases taken in relation to children before, we'll say, the European Court of Human Rights. So to have this climate case was, a huge, big deal, and a really new element of activity of the likes that, people like me that deal in kind of unusual niche of children's rights, children doing political things and children having autonomy and saying what they want and kind of advocating for it. It's incredibly exciting and totally new. So that's the first thing. And the other thing is the emphasis on Indigenous children that was in this petition, and it's quite in line with the work that children are doing in the climate space generally, is that they do tend to emphasize Indigenous issues. And, if you read through the petition itself, you'll be really struck by the individual stories of the children, like Carl Smith from the Yupik tribe in Alaska, describing the devastating impact of global heating on the ability of his tribe to survive, his fears that their way of life would be destroyed, describing friends falling through the ice and drowning as they attempt to herd their herds and so on. So incredibly impactful stuff in that way, and a huge emphasis on Indigenous children. So just to turn to the admissibility point before I just finish up with some of the legacy of the case. I mean, it's been described by some academics as a convincingly reasoned rejection, and really amongst most international scholars there is a real sense of this was an inevitable kind of outcome because of that principle of the need to exhaust domestic remedies. But other academics have really pointed to some significant problems with the committee's determination, like Basak Kali, who's a Turkish academic and lawyer, for example, points out that, at least in Turkey, because there was a separate short communication written by the committee for each country, that in Turkey, she argues that really there's no domestic case law precedent that would allow these children to have any prospect of success, to have the merits of their arguments to be assessed by Turkish courts. So she points to the well-established jurisprudence of Turkish courts that the children would just not have locus standi before the courts. They wouldn't meet the direct victimhood requirement because none of the children petitioners were actually Turkish. And then the committee, when you look at the main issue I have with that is the brevity, the lack of attention that the committee actually gives to, essentially as one substantive paragraph in the 5 or so pages that it communicates, one substantive paragraph outlining how it believes that the legal avenues were available to the children there. And Kali says in one single paragraph, it's, the unlikely to bring effective relief standard of the committee's exhaustion of remedies rule to the ability to file a case without asking whether the case filed has any prospect of success under the rules of standing. And really, I don't think there's enough explanation given by the committee. Fair enough, in Germany and France, you could say that there's evidence there that the success, in Germany, there was a successful climate case, so fair enough. But things like the transboundary element of these cases is very hard to capture. The collaborative work of states that's needed, that isn't happening, is what these cases are about, and I think really where the committee could add value. But just to finish up, the committee did find, that a state can be in theory held responsible for the negative impact of its failure to mitigate climate change on the rights of children both in and outside its territory, in theory. So if there is a case where children do exhaust domestic remedies and still don't get a satisfactory conclusion, then there is all likelihood that they will have a chance of success before the committee. So that was positive. And it's also, been groundbreaking that there's a few kind of procedural things, like it was the first time that the committee used its hearing system, which that Turkish academic actually submitted her report to. It's behind closed doors, so there's only so much we can tell about that, but that was groundbreaking. It also delivered a child-friendly version of its communication, and it also used that opportunity to launch to make known that it was writing a general comment on the right of children to a healthy environment. And there's lots of other things that I can talk about later too. But from that kind of unsuccessful petition has come, excuse me, a lot of exciting follow-ups. And even though it was very disappointing and some of the young people were not shy about giving their opinions on how unhappy they were with the outcome, it's definitely a case of watch this space, because it's far from the end of international climate litigation by children. Thank you.
Thank you very much, Aoife, including for sticking perfectly to time. So that set a great precedent, I think, for our next speaker, who is Cathal, and he will focus his presentation on indigenous right litigation before the Inter-American human rights system. So Cathal, without further ado, I'll hand the floor to you, and of course, we'll be able to come back also to Aoife's remarks later on in the Q&A.
Okay, thank you, Federico. I'm going to put a timer going because I'm talking about a topic that I can talk all day on, so I might need some control at some point. And thanks, Aoife, for that talk, because it actually leads in kind of nicely in a way to the topic I'm going to talk about. And before I get into my topic, I hope I won't digress too much, but in 2006 and 2013, there were petitions before the Inter-American Commission on Human Rights in relation to the impacts of climate change on Indigenous peoples. So there's a precedent for this that's quite interesting. But as Federico said, I'm going to talk on the topic of after Indigenous rights litigation before the Inter-American system of human rights. And I have a few slides because I thought you might like to see something other than my face while I talk. So hopefully you can see that. So when Dave asked me to talk about this or to speak on this topic, I initially thought that I might give an overview of a chapter that I wrote for Dave and Annapurna a few years back on the engagement of the Philippines Indigenous community with the Committee on the Elimination of Racial Discrimination in relation to the destruction of their sacred mountain by a Canadian mining company. And this engagement I was involved in from 2007 to 2012. It had an interesting outcome in that the intended target of the complaint to CERD was the state, but it was actually the company that the community managed to gain some leverage over as a result of that engagement with CERD. And the company eventually recognized their traditional court, and as part of its reparations for harm caused, made an apology to the community. However, in the years since then, I've been involved in quite a lot of work with communities in Latin America. And I thought that the Inter-American system, because it has been so groundbreaking in many aspects of jurisprudence in relation to Indigenous people's rights, was an interesting one to look at in terms of how that jurisprudence has actually helped in concrete cases of Indigenous peoples. So if you talk about Indigenous peoples and litigation, you talk about Indigenous peoples and international law, you have to start quite far back. And as you'll see, that cartoon shows a little bit the relationship maybe that Indigenous peoples have had with international law over the centuries. International law really served to dispossess Indigenous peoples, and where it recognized them, and oftentimes didn't recognize their existence, that recognition was usually just to legitimize the claims of the colonizer over their lands. However, in recent decades, we have seen huge progress in international law, in the field of international human rights law, as a result of Indigenous people's engagement with the shaping of norms and taking cases and the development of jurisprudence. And a lot of that can be kind of synthesized and culminated in 2007 with the adoption of the United Nations Declaration on the Rights of Indigenous Peoples. And since then, there's been quite an acceleration in cases and jurisprudence in this area, the Inter-American system being emblematic, as I said, in that regard. but most of these cases arise in the context of exploitation of natural resources. And this is not really surprising because much of the world's remaining mineral, oil, gas, forest, arable lands are located in the territories of indigenous peoples. And this is also the case for the minerals and the land that we need for our transition to clean energy and to protecting the biodiversity of the planet. So when you think about this, the stage has really been set for David and Goliath type confrontations between indigenous peoples and state and powerful corporate interests. And the inter-American system is to a large degree the legal stage upon which some of these battles are playing out. So in 2007, the year that the declaration was adopted, the Inter-American Court issued this landmark decision of Saramacca versus Suriname. And this decision addresses one of the central safeguards in relation to indigenous people's rights. It was quite groundbreaking. It actually reflects the text of the Declaration on the Rights of Indigenous Peoples, and it called on Suriname not only to consult with the Saramacca, but where any large-scale activity had the potential to have a significant impact on their rights, it said that Suriname had to obtain their free, prior, and informed consent according to the customs and traditions of the Saramacca people. And this was the first time that the court affirmed this, and it's had a significant knock-on effect both in international human rights jurisprudence. So I've listed a few cases like the Pomo case versus Peru before the Human Rights Committee, also at the regional level in Africa, and very importantly, and for what I'm going to discuss now in the rest of the presentation, at the national level. And I'm going to use two examples, one from Colombia and one from Brazil, to highlight a little bit how the after of this litigation, this particular litigation, has been useful for indigenous communities across a range of jurisdictions. So the communities that I'm going to talk about, the first is the Juruna people in the state of Para in Brazil. So I visited this community when working with the UN Special Rapporteur on the Rights of Indigenous Peoples in 2016. And I've been engaged with them and the other community I'm going to talk about in Colombia over the last 7 or 8 years in the context of research and also advocacy work to try and strengthen their rights frameworks. But the Juruna people, to give you a little bit of background, they're located in the Brazilian Amazon, in what was a very remote area. But in the early 2000s, they were faced with the construction of the biggest hydroelectric dam in Brazil, known as the Bellamonte Dam. I don't know if any of you have watched the movie Avatar. Well, it's based on this story, basically. So the Juruna filed a petition before the Inter-American Commission in 2011 because there had not been consultation with them about this project and its impact. The Commission, in turn, issued precautionary measures to Brazil, calling on Brazil to suspend the project until a proper consultation had taken place in accordance with the jurisprudence of the Inter-American system, which included the Saramacca case that I've just mentioned. The Brazilian government didn't take kindly at all to this and accused the Commission of infringing on its sovereignty, threatening its sovereignty. It suspended its funding to the OAS, to the Organization of American States, which was about $800,000. And it threatened to withdraw from the organization. So you can imagine the pressure that it put on the Inter-American Commission when this happened. And despite the fact that this case garnered a lot of global attention in global media and also national attention in Brazil, the government pushed through with the project, and in 2015, the dam was constructed. The Brazilian federal prosecutor described the impact of that dam on the Juruna as ethnocidal. And it talked about the destruction of the community social organizations, the impact on their languages, on their customs, the displacement of people. And those impacts continue up to today. And the Inter-American Commission continues to monitor that, and visited the community, and has told Brazil repeatedly that it needs to address the violations and to follow, in any future projects, to follow the decision in the Saramacca case to consult in order to obtain consent. Of course, what's happening in the community doesn't reflect what the Commission has instructed. And there's a major project, the largest gold mine in Brazil, and one of the, I think the third largest gold mine in Latin America, is proposed right in this territory, a few kilometers from where the Juruna people live. So faced with this threat, which is existential for the Druna, they came together and devised what they call their own consultation protocol. And this is where an Indigenous people define the rules and principles that should guide any consultation with them between states or corporate actors. And what's very interesting about this case is that the Druna, in parallel to doing that, took a legal action in Brazil against the mining project, the Belo Sun mining project. And the federal court affirmed in 2017 that any consultation with the Druna should follow this protocol. So that's very empowering for the people. It changes what the very fundamental basis of engagement with them is now to be on the basis of their principles and their rules. And this enabled the Druna to have the environmental impact assessment that had previously been authorized cancelled. It also enabled them to continue in further legal struggles with the company. And those struggles are ongoing. And they include complaints to the Ontario Security Commission that the company, by not declaring the fact that there are legal challenges pending, is not disclosing in accordance with Canadian law. The decision also had impacts and implications for other communities, not just the Druna. So there are other Indigenous peoples in Brazil who are using their protocols to ensure that government agencies consult in a way that's consistent with their procedures and rights. But it also is being used to insist that investors who are monitoring these projects ensure compliance with the protocols. And the investors who are investing in a very large railway and road infrastructure project, for example, near the Xingu River, have said that any agreement with the Indigenous people must be compliant with their protocols. So that's the Brazilian example. In Colombia, a very similar pattern emerged. This was in the context of the territories of the Embera Chami people in Caldas in Colombia. You can see up there on the map, the far west of Colombia. And these people have a history of ancestral mining, small-scale ancestral mining. But they discovered in 2010 that their reserves, their territory was completely covered in large-scale concessions. They had not been consulted in relation to this. And the Colombian context is really interesting because the Colombian Constitutional Court has essentially had a dialogue with the Inter-American Court and has grounded much of its jurisprudence in that jurisprudence of the Inter-American Court. So it's elaborated on the decisions such as the Saramacca decision, applying them in the Colombian context. And in 2016, it addressed the case of the Embera Chami. And it, again, just as the Brazilian court had done, called on the Colombian state to ensure respect for the protocol developed by the Embera Chami. Again, we see very concrete outcomes of this. So in a context of violence where the leaders of the Embera Chami people have had precautionary measures since 2002 from the Inter-American Commission, their community has managed to keep out large-scale mining projects as a result of the protocol. So the community leaders, and this is their own language, they describe it as a beacon of hope in the context of violence. And it's very much part of a broader strategy of territorial government, territorial self-government and defense of their lands. So the interesting, I think, thing about the protocols is that they reflect not just the particular community's perceptions of how to be consulted, but they're also shaping international human rights law. And this emerges from a body of jurisprudence that's developing, coming from human rights treaty bodies, from special rapporteurs, from the Inter-American Commission on Human Rights, from various expert bodies that focus on Indigenous peoples, that are all describing these protocols as the basis upon which Indigenous peoples should be consulted. So it's actually fleshing out what is a principle in international law and giving it content. And for Indigenous peoples who have engaged in litigation with the Inter-American system, I think these protocols, you could view them as like another arrow in their quiver that they can use very strategically in the context of a broader strategy to defend their territories. And one such community, going back to the start of my talk, is the Saramacca in Suriname. So the Saramacca people, having looked at what communities such as the Druna and the Embera Chami have done, have decided to develop their own protocol. So now they're in a process together with other indigenous peoples in Suriname to do this in order to further the implementation of that decision taken in 2007, which in Suriname, 15 years ago, the Surinamese government has still not recognized them as an indigenous people, let alone demarcate their territory or attempt to obtain their consent. So at the level of the individual people, it can be quite empowering, but also on a macro level for the indigenous people's movement as a whole. I would say that this litigation, it's contributing to a continuous process of establishing and reinforcing norms that have been developed in international human rights law and infusing those norms with indigenous people's perspectives on law and justice. And ultimately, that's, I think, one of the real contributions of this protocol. And the after is, as with anything to do with indigenous peoples, we're talking about centuries. The after, we're looking at one point in time. Let's see where this goes. Thank you.
Thank you very much, Cathal. Also to you, also for sticking to time, and very interesting presentation. The principle of consent rings a bell also closer to home, of course, but it's important to see that this is developing as a principle of public international law more generally, I would say, on the basis of your presentation. But we'll come back to that. Next speaker is now our own David Keane, who is going to focus his remark on the Convention for the Elimination of Racial Discrimination, CERD, and recent interstate communication related to Qatar. So David, the floor is yours.
Thank you, Federico, and thanks, Aoife and Cathal, for your presentations. Really, really interesting. So I trust my sound is okay, and I'm going to shift the dynamic a little bit. So we've heard from Aoife and from Cathal about human rights litigation that is occurring or that is being taken by individuals or by communities or by groups of individuals, certainly, in relation to an individual communication before the Committee on the Rights of the Child and similarly case law before the Inter-American Courts. What I'd like to talk about is interstate litigation. So here, in particular, Qatar's interstate communications before the UN Committee on the Elimination of Racial Discrimination. So well, now you can see my slide. So the cover or the photograph is of the GCC, the leaders of the Gulf Cooperative Council states agreeing what's known as the Aola Declaration in Saudi Arabia, which ended the blockade of Qatar. So it was a diplomatic agreement that ended the blockade of Qatar last year. Now, what's interesting from the perspective of human rights law is that Qatar had taken the very first interstate cases ever taken before a UN treaty body. So with the diplomatic agreement reached at Al-Ula, Qatar's interstate communications, the first ever, ended, or rather they were suspended and will probably end as well. So they reached about the halfway point, as I shall describe. So what I wanted to discuss was, first of all, the communications themselves, the context in which they arose, the legal provisions that governed them, and what they achieved, and how we can perhaps consider their achievements, even though they ended, as I mentioned, at a particular stage. We haven't had confirmation that the communications have ended, but we will. That is likely to come. So first, just to briefly, Federico mentioned it is the International Convention on the Elimination of Racial Discrimination, is the first of the UN human rights treaties, 182 states parties, so more or less close to universal ratification. It has two mechanisms for interstate cases. Firstly, one state can take another state before the committee, the UN Committee on the Elimination of Racial Discrimination, or CERD, and a state may also bring or refer a dispute to the International Court of Justice under Article 22. The provisions, or its interstate provisions, were modelled on an early draft of the Covenant on Civil and Political Rights from 1954, and that early draft of what would become the ICCPR, the International Covenant on Civil and Political Rights, that draft CCPR provided a compulsory interstate communications mechanism. So any state that ratified the treaty could bring another state before the draft Human Rights Committee. It also provided for a referral of the dispute to the International Court of Justice. This was in the third committee, or when they were finalizing the covenant, they changed the interstate provisions in the covenant. They made them optional, which meant that each state on either side had to opt in order for an interstate communication to happen. And similarly, they removed or eliminated the clause allowing jurisdiction of the International Court of Justice. So following on from the ICCPR, every other UN human rights treaty, and we have 9 in total, the interstate provisions are optional, which means both states must have opted in. Some don't provide interstate provisions at all, such as the Convention on Elimination of Discrimination Against Women. But for those that do before the UN treaty body, they are all optional. CERD is the only one where its measures of implementation did not undergo the same revisions as the ICCPR. So based on that early draft, it brought in compulsory interstate communications mechanism, and it stayed compulsory. So when ICERD was ratified, its interstate communications provisions are compulsory. They apply to all states parties, and it is the only treaty that provides that in the UN system. Now, some commentators have sort of reflected on that and thought that perhaps they remained compulsory as some sort of Cold War dynamic. The Soviet Union wanted to use racial discrimination as a propaganda tool against the West. But it's clear that there was widespread support among countries for keeping the interstate provisions compulsory, perhaps with apartheid South Africa or others in mind. So they remain compulsory and uniquely so. And CERD would later draw attention to the unique nature of the mechanism established under 11 to 13 of the Convention, which is unlike interstate communication procedures in any other human rights treaty. So we have 2 mechanisms, one before the committee and also Article 22 before the International Court of Justice, the strongest provisions in the UN human rights system. Besides the strength, or despite the strength of these interstate provisions, they remained unused for around 50 years. Generally, interstate provisions are much less popular than individual mechanisms. Those who study the European Court of Human Rights will know that there are far more individual cases than there are interstate cases. Nevertheless, once they started, there began to be, as you can see, an acceleration. So they started first under Article 22 before the International Court of Justice with the Georgia versus Russia case. We've now had 5 interstate cases taken under Article 22 of CERD before the International Court of Justice. 4 of those are in the last 4 to 5 years. So this has led to some criticism that CERD is a vehicle or a convenient vehicle for bringing disputes before the court, which are not really about racial discrimination. So in a recent dissenting opinion of the president of the ICJ, Yusuf, in Armenia versus Azerbaijan, he said the court has thrown wide open the gates of ICERD to all kinds of claims that have nothing to do with provisions or with its object and purpose. Claims under humanitarian law were given a home in CERD. This risks transforming the convention into a receptacle into which all sorts of asserted rights may be stored. So there is a sort of perhaps a perception that maybe this treaty about racial discrimination is being used to bring conflicts before the International Court of Justice. And we get to have a decision of the ICJ on the merits, so perhaps those arguments have yet to be fully determined. But what I'm more interested in is the use of the Articles 11 to 13 mechanism. I should point out that many states have a reservation to the ICJ clause, so it does not apply to all states parties to ICERD, whereas 11 to 13 before the UN committee does. So it applies to all 182 states parties to ICERD and provides a rare universal adversarial jurisdiction in human rights law. So there is no Asian Court of Human Rights, for example. So it brings in a lot of areas which are perhaps difficult to capture in adversarial proceedings before UN or international bodies. 3 interstate communications were initiated, first 2 by Qatar, and then Palestine versus Israel. And Saudi Arabia and Israel have a reservation to Article 22, so those disputes can only be determined before the committee. So these were pioneering. Qatar's communications were pioneering as the very first interstate communications ever taken before a UN treaty body. So in that regard, they provided a new pathway or a new mechanism, and as we know, there's really only state reports, individual communications, interstate communications, and some other mechanisms as well. But they opened the door on this mechanism at the international level. So we've had case law, as I mentioned before, the European Court, but we've never had it at the UN level before. So Qatar's interstate communications took place under Articles 11 to 13. It's interesting to note that Article 11.1, if the state party considers another state party is not giving effect to the provisions of this convention, they may bring the matter to the attention of the committee. So There is no requirement of direct victimhood under Article 11. Any state party can bring another state party before the committee. You could get what you might call public interest interstate litigation before CERD. We've seen that before the European Court or the European Commission, as it was before. The Greek case, for example, involved a number of European states taking Greece under its military coup in the 1960s before the Commission. And we see before the ICJ, the Gambia versus Myanmar case involves, again, a sort of a public interest case where the victim is not the Gambia, but rather the Rohingya in Myanmar itself. So that's possible, but the interstate communications that have been taken to date have all involved direct injury to the state itself, at least alleged. Qatar's triggering of the mechanism, once it did, so it's interesting that almost every single procedural aspect of an interstate communication had to be determined, or was required to be determined by the committee. So it was guided, of course, by the provisions itself, but its own rules of procedure only covered the very first step, Article 11.1, and didn't really provide any guidance on the substantive steps, the substantive procedure required for an interstate communication. So CERD had to draft new rules of procedure in 2019 to cover all aspects of the interstate communication. And it had no precedent, as I mentioned, in the UN human rights system to draw on. So Articles 11.2 to 5, they involve issues or questions of jurisdiction, admissibility, and of the hearings that take place themselves. So the importance of these new rules of procedure, for example, Article 11 doesn't say anything about whether the hearings should be public or private. CERD's new rules of procedure determine that the hearings should be held in private. So they are closed hearings involving Qatar, Saudi Arabia, Qatar, UAE, and Palestine versus Israel. They also affirmed the differing roles of the committee and of the Ad Hoc Conciliation Commission. So Article 12 sets up an Ad Hoc Conciliation Commission to determine the merits of the communication. And the rules of procedure determined also that the committee only figures in the first step in preliminary issues. So it only determines the preliminary issues. Qatar's first communications, so they decided firstly the rules of procedure, secondly they decided the differing roles of the Ad Hoc Conciliation Commission, which I'll come to, and the committee itself, that the committee decides on jurisdiction and admissibility, and the Ad Hoc Conciliation Commission decides on the merits. It also reached a number of substantive points. It decided on a new admissibility standard in interstate cases. So it found that the exhaustion of domestic remedies is not a requirement, where there is a generalized policy and practice that has been authorized by the respondent state. So reference the European Court of Human Rights, which is a similar standard for interstate cases, and the importance of admissibility was mentioned as well in Aoife's paper. So this different standard in interstate cases, that you don't need to go through the domestic mechanisms in the same way if you can set out prima facie a generalized policy and practice. So that's what Qatar did, and that's what Palestine did as well. And the committee affirmed this different admissibility standard for interstate cases. Another decision that was reached by the committee was in relation to the scope of the convention. The convention covers national origin as one of its 5 grounds. The cases of Qatar's cases involved the expulsion of Qatari nationals, and the committee found that national origin includes nationality, so that the expulsion of Qataris is covered by the term national origin. Now, the Qatar versus UAE case was also before the International Court of Justice, and about a year later, the ICJ ruled on the same issue and reached the opposite conclusion. So the ICJ determined in its preliminary objections judgment in Qatar versus UAE that national origin does not include nationality, and so Qatar's case failed before the ICJ. So that leads to interesting questions as to who is the ultimate arbiter of the convention. Is it CERD or is it the International Court of Justice? The next step then was the Ad Hoc Conciliation Commissions, and generally once Article 11 is complete, once the committee has determined preliminary issues of jurisdiction and admissibility, then an Ad Hoc Conciliation Commission is formed. Now, this is formed of 5 persons, and it is formed compulsorily, sorely. It has to happen if the Article 11 steps are satisfied. We find an Ad Hoc Conciliation Commission in 2 other UN treaties, the ICCPR and the Convention Against Torture. But again, it's optional. So once you finish the first steps, the states can, if they wish, or if they consent to it, form a conciliation body, or have a conciliation body formed. Under CERD, it's compulsory. So the compulsory mechanism of the forming of the conciliation body can be done in two ways. Firstly, the parties agree to it, or secondly, they don't agree and it is formed anyway. So what we got in the Qatar communications was that they did agree to the conciliation bodies that were formed, and when they agree to it, they can appoint anyone. There's one or two requirements, but they can appoint anyone to the conciliation bodies. So the two Qatar commissions were formed of both external and internal CERD members. So you can see the members there in Saudi Arabia and in the Emirates communication. Those in bold are not CERD members. So you could have outsiders brought in to determine the merits of the claim as members of the Ad Hoc Conciliation Commission. But I mentioned it's a compulsory mechanism, so if they cannot agree, then CERD elects the members of the conciliation body from among its own members. And Israel, once the decision on jurisdiction was reached in Palestine versus Israel, felt that the mechanism of the procedure was biased, refused to participate further, didn't nominate anyone or didn't agree with Palestine on who would be on the commission. And so in Palestine versus Israel, the commission is formed only of CERD members elected from their own members. So the mechanism continues anyway, whether the states agree to the members of the commission or not. And so we get the two types of the formation of the commission in Palestine versus Israel. So in relation to the Qatar communications, and just aware of time, the Aola, the commissions were formed, the two commissions were formed, and then the agreement was reached in Aola in Saudi Arabia, and so the proceedings were suspended, and the Ad Hoc Conciliation Commissions were to remain seized of the matter, however. So they decided to give Qatar a year, that was in fact a term within the Aola agreement, that Qatar would take a year to decide to discontinue its various international proceedings against its neighbours, and the conciliation commissions remain seized of the matter. So it's interesting to note that the CERD mechanism continues anyway, albeit suspended, although the ICJ decided that it didn't have jurisdiction. So the independence of the CERD mechanism is perhaps affirmed by the conciliation bodies remaining seized of the matter. So the CERD mechanism is independent, although there are also links with the ICJ mechanism. So the Qatar will probably be dropped, so which leads us to, I think, conclude or some conclusions as to what it achieved. But firstly, they were the first ever interstate communications taken. Because the mechanism is divided up clearly into different steps, they achieved the completion of the first step, which is the preliminary issues of jurisdiction and admissibility that occur before the committee. So it succeeded in the completion of that. It also provided us with a different model for the appointment of the Ad Hoc Conciliation Commission than would happen in Palestine versus Israel. And that different model, perhaps, or that different route under 12(1)A shows us the two sides of this interstate communications mechanism. It does two things. Firstly, it's a dispute resolution mechanism between two states, but it's also a means of collective enforcement of the treaty. So even if the other side doesn't agree or doesn't consent, it happens anyway, it continues anyway. So Palestine versus Israel shows that collective enforcement role of the interstate communications mechanism, whereas the Qatar communications better illustrates that dispute resolution role, that bilateral dispute resolution role. So it falls to Palestine versus Israel to complete the interstate communications mechanism, to pioneer the merits phase, which is what will happen in the coming year or 2 years. But the Qatar communications opened the door for interstate cases at the UN. Okay, thanks. I'll take any questions.
Thank you very much, David. That was much appreciated and extremely interesting. And I think we can safely move straight to Annapurna, definitely our last but not least speaker in the panel, who is going to focus, as I understand it, on caste litigation in the United Kingdom and the United States. So Annapurna, thanks a lot for being with us, and the floor is yours.
Okay, so I was asked to talk about caste litigation in the US, which is an enormous topic. So I'm going to do the best I can to keep it simple and short. So the issue that we're talking about is identifying and naming a form of discrimination that has been invisible, certainly in the West, making it visible. And the question is, how do we get legal and social recognition of this form of discrimination and establish routes for legal redress? So the two obvious routes are campaigning for legislative and policy change, alternatively judicial interpretation of existing provisions. So I suppose the sort of big overarching question is, what does success look like if you've got these two different routes that you're trying to use? I always, you have to, there is a need to explain what caste is, but this is just like one slide. I'm not going to dwell on this, but essentially we're talking about a form of social organization and social identity which involves hierarchy, discrimination, separation. It's not unique to Hinduism, it's across all major religions in South Asia. And it's not just in India, it's also an issue that a phenomenon that occurs in the South Asian diaspora, so specifically in the UK and the US that I'm going to be talking about. The conundrum is the grounds-based model of discrimination law. So if there's no legal recognition of your particular form of discrimination and no redress, it's not captured in law, then there's no redress. So it's really essential that the form of discrimination that you are talking about is captured in law. And if it's not, then you have a problem. I'm sorry if this is sort of teaching things that you already know, but obviously the way to get around that is either to add more grounds of discrimination or to extend the existing grounds by judicial interpretation. In other words, by litigation or even by legislation, but in some way you're wanting to expand what you've got. And there are different ways of doing that. We were just talking about the conundrum of protected characteristics and models of discrimination law based on grounds of discrimination, which is the sort of majority model, and how you can address that. So in 2009, we had debates for the Equality Bill in the UK Parliament, new equality legislation. And the two big questions are, or were, does caste discrimination exist in the UK, and what should be the legal response? So there was consultation on this bill from 2005 onwards, and various groups lobbied for inclusion of new protected characteristics, in particular anti-caste and Dalit activists. And the question, does caste discrimination exist? I've just included this one little slide. I took out the others, but this is something from a blog which quite recently on, say for young people, looking at intercaste marriage, typical parent reaction. It sort of gives you an idea that yes, actually, this is still an issue in the UK. So what do different groups say about this? Anti-caste activists say, yes, it does exist, and there are reports and academic research to that effect that make that point. What did they want? They wanted legal regulation of caste discrimination, and they wanted legislation. Parliament, initially, governments weren't sure caste discrimination existed, but by 2015, they had changed their position. Their position about legislation, legal response, hasn't changed, or rather it's shifted only slightly from no need for a legal response to relying on existing provisions in equality law, but not new legislation, not a new protected characteristic. Anti-caste activists, anti-caste legislation activists, no, caste discrimination doesn't exist, and if it does, it's not in legally regulated fields. They don't like caste as a term. They feel that is racist towards Hindus. They oppose any legal regulation of caste discrimination, including judicial interpretation of existing provisions, which is a tricky one, isn't it? Because there's no control over what judges decide. They are networked with opponents of caste legislation worldwide. So looking at the UK first, what has happened? There's a rundown, which is probably a bit too much to take in detail, but essentially in 2010, the government included a power in the Equality Act for the future inclusion of caste as an aspect of the protected characteristic of race. The reason for this there was skepticism, there's no need for legal regulation, something that doesn't exist. In 2013, Parliament amended the Equality Act and converted that power into a duty, but the government did, successive governments, I should say, did nothing. In 2015, there was a case of a case involving claims of caste discrimination, which resulted in it was an employment tribunal case, resulted in a decision that in certain circumstances, caste might be captured by the ethnic origins limb of race by virtue of the descent element of ethnic. And that is from the JFS case, Jewish Free School case. But that decision is not a precedental decision. The judge specifically said this is not setting a precedent. By 2016, we've got the UK agreeing that legal protection from caste discrimination is appropriate, but they're saying that this judgment establishes that such claims can be litigated under the Equality Act as it currently exists. And then they've gone further. They introduced a public consultation, offered a so-called choice of legislation or case law, and in 2018 announced that they would repeal the duty to add caste to legislation. This is the decision of Turkey and Chandok, and you can see that it is hardly a sort of a completely concrete watertight decision on caste falling within ethnic origins and descent. The relevance of descent, I'm not talking about international law in this today, but the relevance of descent is that descent is one of the limbs of the definition of racial discrimination in the International Convention for the Elimination of Racial Discrimination. And it's the limb that has been applied by CERD, by the committee, to caste. So caste under international law is considered a form of racial discrimination as a form of descent-based discrimination. Okay, so why is it so fraught and controversial? And this will lead on to the UK. Arguments in favour of legislation, objections, I've sort of touched on those, and in a way, we know what those are. The importance of legislation for naming, for identifying the mischief that you want to address, so that it is recognised, so that there is a clear route for legal redress. There is no need for this preliminary hurdle of trying to establish that caste is captured by the existing grounds of discrimination. Objections to legislation, what's really interesting is that these same objections are now appearing in the US. So mainly from religious groups, that caste discrimination legislation is anti-Hindu, racist, that caste is not a concept, an Indian concept. It was introduced by the British. It's got nothing to do with India. Why have successive UK governments avoided legislating despite that 2013 obligation to do so? Well, that's an interesting one. I think that in Britain, there's a lot more squeamishness about legislating against this form of discrimination because of the fear of upsetting religious organisations, but also because there's a sort of natural antipathy to introducing more protected characteristics. Interestingly, in the US, I think there is a lot less squeamishness about this, and I think that is to do with the civil rights history of the US. We'll see that in a second. Essentially, the UK anti-caste focus was on legislative change because that is something that it is possible to achieve in the UK. But as that possibility has receded, the focus has turned to litigation as the government, the direction the government, successive Conservative governments have wanted to take it in, and also influencing the promised guidelines on caste and equality law, which the government said they would produce in 2018, but haven't. But interestingly, in a 2019 case, relying on ethnic origin didn't work. So it's clearly not a panacea. This claimant was not able to get beyond the preliminary hurdle that that the discrimination he'd suffered was actually captured at all by discrimination law, by equality law. Okay, so in the US, I've just got a few slides here on the nature of caste discrimination in the US. Equality Labs, a CSO, a civil society organization, NGO, did a survey in 2018, and these were the results. So their surveys, although there were methodologically some problems with it, but it does indicate that caste discrimination is a thing in the US, which is not really surprising given the numbers or the level of immigration from India into the US. Question one, does caste discrimination exist in the US? I think the answer is yes. Question two, what should be the legal response? So in the US, legislative change, certainly at the federal level, is much harder than in the UK. So you're really looking at policy change or litigation relying on existing provisions. And the same issues are now appearing in the US as in the UK. So the model, the anti-discrimination law model in the US, you've got these two federal statutes when we're talking about racial discrimination. So Civil Rights Act, Title VII, and what they call Section 1981. So there is no definition of race in the Civil Rights Act, but the federal body that is responsible for enforcing federal discrimination legislation includes in the definition of race, in its guidance. So this isn't in the text of the statute, but the guidance, in discrimination on the basis of ancestry. So we can immediately see there a similarity with the notion of descent. And indeed, in the JFS case, when descent was being discussed as an element of the concept of ethnic origins, the term ancestry and antecedents were used by the Supreme Court in the UK. It was the first Supreme Court decision in the UK, and it cites David's book as well. The Employment Equality Opportunity Commission, EEOC, in the States, which enforces federal discrimination legislation, it has no power to amend Title VII. So amending federal law is very difficult. But what it can do is issue what it calls opinion letters on the interpretation and application of these laws. So one of the demands is that the EEOC issues a statement confirming that race, which it's already said includes the notion of ancestry, does cover caste for the purposes of Title VII. I think if you went back to the Title VII slide, you would see that I'll just do that really quickly. If you see Title VII, the grounds of discrimination are quite limited: race, colour, religion, sex, and national origin. Let me go forward. In 2020, there was a really significant decision, which some of you may be familiar with, which was Boston and Clayton County. And so Title VII doesn't cover sexual orientation or gender identity discrimination. And Boston and Clayton County held that this sexual orientation was a form of sex discrimination because, but for the person's sex, they would not have been subjected to this discrimination. So the argument, sort of extrapolating from that, this argument is being made now that casteism is a form of race-based discrimination because it only poses a threat to South Asians. In other words, so the argument in Bostock is if you change one thing, would it make a difference? So if the discriminated against person was not a South Asian, they could not be discriminated against on grounds of caste, because caste is only a feature for South Asians. So it's an argument that it wouldn't work in the UK, but the reasoning is that if John Doe, the anonymous claimant in the case we're about to see, had not been a South Asian, he would not have been subject to caste-based discrimination. So there's an argument that Title VII, because of the Bostock decision, can be applied to the case of caste discrimination. And the case in question we're talking about is BFEH and Cisco Systems. It's a 2020 case, and this is a claim of caste discrimination, which was brought initially under Title VII and also under California state legislation, because alongside federal discrimination legislation, there's also state anti-discrimination statutes. This was a claim that was launched by the body, the human rights body responsible for enforcing California's human rights legislation, which is confusingly called the Fair Employment and Housing Act. And the Department of Fair Employment and Housing filed this claim, which is ongoing at the moment. Similar issues to the UK, that Cisco, this is a big tech company, applied to the court to have the case thrown out on the grounds that the victim had signed an arbitration agreement which prevented him going to court. That was that application was thrown out, but they've also put in an application to strike out, exactly as in the Turkey case, on the grounds that caste discrimination isn't actually prohibited by law. So at the moment, these hearings are stayed pending the arbitration appeal. In the meantime, the Hindu American Foundation has intervened, arguing that the connection of caste to Hinduism is culturally discriminatory and anti-Hindu, and that's why the case should be thrown out, because it violates the Constitution. Why is this an issue? Because there are many Indian origin workers in the US tech sector, and they're predominantly from the dominant castes. So there's a bit of information there. These H1b visas, which are the visas for foreign nationals engaged in specialty occupations, they are very predominantly going to workers from India, 72% of all of them. So this state legislation has got a bigger list of grounds than Title VII, and so the argument is there's ancestry specified, as well as race, colour and national origin. So in this Cisco lawsuit, a Dalit organisation called the Ambedkar International Centre filed an amicus brief, and the argument is that caste discrimination is captured by the concept of ancestry, but also by the concept of race and colour. And this is an amicus brief that I've been involved in drafting. So it was this international centre that put together a kind of consortium of lawyers who had been involved in these sorts of issues from the US and me from the UK. There's one other case which I'm going to skip over, a second case. But I think the key point here is that this is Kevin Brown, who's one of the people in this a legal advisory group. And he's a long-standing academic on civil rights issues. And the connections are being made very strongly between Black communities in the States and lower caste communities. And one of the things that is being cited is the dissenting judgment of Judge Harlan in Plessy and Ferguson. There is no caste here. Now, we don't have the equivalent of that in the UK, but this judgment and other similar references to caste in American jurisprudence, both pre and post civil, or particularly pre-civil rights, is being relied on now in these cases. So this is a conclusion. Each state will tackle this problem differently. It's not an issue that will go away. There is a value in litigation, value in activism, and value in global connection. And at the moment, it seems that it is litigation, which is the only possible route in the US, and now in practical terms, for now, the route in the UK. But the grounds of discrimination are interpreted differently in the UK versus the US, and that is where the problem lies. Okay, I'll stop there.
Thank you, Annapurna. No, I think it provides lots of food for thought for conversation for sure. We have exactly 15 minutes, so I am keen on opening immediately the debate for questions from the audience. If there's any, just please, since it's a small crowd, raise your virtual hand and we should be able to unmute you. And if in the meanwhile, perhaps while we wait for some questions to come from the audience, I also would like to give an opportunity to the speakers to react to each other, perhaps to share thoughts on each other's presentation and the like. And if you agree, we might just go in the same order of presentation. So Aoife, I don't know if you want to add something in light of what your fellow panelists said.
I was just listening really intently to all of the panelists and just kind of struck at the diversity of actions, going on in the respective areas. And I mean, I suppose one of the things that I would be quite interested to hear is the point about exhausting domestic remedies, because I know that that's a controversial one that I rose in the climate context, and I was wondering whether there was any pressing issues in relation to exhausting domestic remedies, or whether the other speakers had any thoughts on that element of the climate case. So I'd be interested to hear on that, but I'd be probably more interested to hear questions from the audience in any case.
Thanks, Aoife. Cathal, do you want to step into?
Well, I'd also be interested to hear questions from the audience. Feel like they've heard enough from me. But I found the talks fascinating, and I already mentioned Aoife's this very close link between Indigenous people's issues and this climate change area. I think a lot of the I don't want to start talking too much about a lot about the kind of developments in relation to the link between human rights and environmental law are coming from Indigenous rights jurisprudence and litigation. And that's very clear in the advisory opinion of the Inter-American Court in 2017, which if you look at the footnotes, it's 50–60% of it is coming from Indigenous rights cases. And I found your presentation fascinating. It's triggering lots of thoughts. But one of the kind of amusing thoughts that came to my mind is if say that case of linking to South Asians and therefore being able to link to descent. But at what point does somebody not become a South Asian if they're descended from a South Asian? You have to say descent-based discrimination. This is the fact that you're descended from a South Asian. So it's funny.
One of the things that has fascinated me is working with American lawyers, because they're incredibly gung-ho and they really aren't bothered by the sort of things that there's sort of niceties that as I was a practicing lawyer before I became an academic, they're much less cautious. They're very, very into the detail, and they are hugely into litigation. So the Bostock judgment in itself, I mean, there's been commentary on that in the UK, and I can't imagine a similar judgment in the UK. But the extrapolation to cast is really interesting. And yes, if but for the fact that you're South Asian or Indian, this wouldn't have happened. What do we mean by South Asian? It doesn't seem to have bothered them particularly. And the other thing I would say, which I didn't say in the presentation, is that they are absolutely not interested in international law. So there's me kind of trying to say, well, of course, under the race convention, the concept of descent, that must go to, because the US has ratified it, that must go to bolstering, the argument about ancestry. And they're like, no, the judges in the US won't be interested in that at all. They're only interested in US law. So I don't know if any of you have worked particularly with US lawyers, but that kind of struck me a lot. I was quite shocked. Maybe I'm naive.
There's a big discussion, of course, on the value of foreign law and international law in the US and all that.
Yeah, well, I sort of assumed, because we were in a human rights discrimination zone, that these lawyers would be more amenable to consider, you know, but they weren't.
Yeah.
I found Aoife's paper really, really interesting. It's I've just started teaching environmental law and human rights at my institution, and the children's petition obviously was something that I looked at, and so it was really interesting to hear your paper on that. I learned a lot, and well, all of them, all three, really, really interesting, fascinating. And interestingly, my paper didn't raise international law issues, so it was much more kind of domestic focused. But the international, certainly in the UK, international developments at ICERD have been historically really important for driving the demand for legal change.
Thanks, Annapurna. I think we can now move to Mengting Wang, who is one of our PhD students, and he had a question for Aoife. So I'll ask Mengting to actually ask the question directly, perhaps.
Oh, yes, I have a question for Aoife. So in Europe, children are traditionally protected. As child protection on the internet is currently inadequate, in some cases of children as victims, such as the abused or exploited, children's right to protection is often restricted by some European fundamental human rights, such as, for example, the right to free speech of the perpetrators. So in litigation, how to handle the conflict between fundamental human rights and the children's right to protection? And in your books, you know, you talked about the more autonomy. So can empowering children more autonomy resolve this? Thank you, Eva.
Yes, that's a fantastic question. And I could literally sit here and talk about it all day long, because like you said, I've written a book on children and autonomy. So there's so many things I want to say, but what I will just kind of briefly refer to is that, you know, a proper understanding of autonomy, as I lay out in my book, includes acknowledging where we need protection. Autonomy we have in our minds as is a selfish thing where we do everything on our own, and that's not what a proper understanding of autonomy is. We have vulnerability as well, and they go hand in hand. We've relationships to other people, our parents and so on, they also go hand in hand. But there's no easy answers in this space, but actually I'm putting in a big proposal to look at child-friendly justice in this area, because I think there are a lot of questions about children, and on the amazing side, it's kind of reinvigorating our views on children as various societies. But on the other hand, what children's actual role is, how child-friendly is the justice, what experience are they having when they undergo it? Those are questions that I think we need to get to. So I would love to talk about it all day, but I hope that has given some little bit of insight. Thank you.
If I might abuse my role as chair and also take the opportunity to ask a question, we still have 5 minutes. I just wanted to ask a question to Annapurna. And it's mostly on U.S. law that you were mentioning also in your latest remark. I've been a student of U.S. constitutional law for many years and doing some work and research myself on U.S. federal human rights issues in many ways. And the question I had about sort of the role of the Supreme Court, the role of the Civil Rights Act, the Voting Rights Act, another sort of civil rights instrument that the U.S. adopted at the federal level. I wonder to what extent you see them as being realistically instrument for promoting sort of caste litigation in the U.S. Clearly, all of this instrument found their historical origin in the problem of sort of slavery and Jim Crow, the sort of the segregation of African Americans, the black people in the South. Clearly, then they are drafted in neutral language, so they can definitely, I mean, those texts can definitely be exploited for other human rights purposes. But I wonder to what extent that is likely, given, in fact, the recent rollbacks that we have seen at federal, judicial, and legislative level, from limitation of voting rights to the unwillingness of the Supreme Court to take up big fairly striking violation of constitutional civil rights even sort of the groups that were originally the target for those instruments. So I'd be happy to have your thoughts.
Well, first of all, I'm no expert student of American constitutional law. My kind of foray into American law has come by being asked to contribute to their to these cases and sort of help with the amicus brief and help with other documents that are being drafted. So I'm not an expert, but my sense from being involved in these meetings and from what I've learned is that it's much more political. That sounds very naive in a way, but it's so much more politicized than in the UK that almost the focus, from what I can see, the focus in terms of getting things done seems to be on federal legislation. So, there is so much of discussion about, the personalities, the politics of those involved at the federal level, even in bodies like the EEOC, even those bodies are subject to sort of, political appointments, and, it's so much more present as an issue than in the UK. So my experience in the sort of 2 years or so that I've been involved in this caste litigation with American lawyers, and I've never met them in person. It's all been online, but we've had endless, very long meetings, and it is very much about state legislation and the use of state legislation, much more than federal legislation. Even though, I mean, for example, Cisco filed under Title VII and also under California state law, but then they retracted their filing under Title VII, and they haven't refiled under Title VII. So, yeah, if that answers your question.
Yeah, that's a very good point. Thanks, Annapurna. Listen, I think it's only fair now to go back to David and give him the last word.
I mean, thanks to Federico and to Andre for organizing, just to say that. But great to have the speakers. I think there were many different threads, and I don't think we had enough time to explore all of them. So I do think it's interesting. I sort of tailed off discussing exhaustive domestic remedies with Aoife, but I do think that exception that was provided by CERD might be something to consider in light of certain individual communications that might show these larger patterns, that maybe there's an argument there. So next, in relation to Cathal, I mean, I found it fascinating. We did the Inter-American system yesterday in my master's class. I think I see at least one of my students who was here. So I guess for Cathal, I did, discuss free, prior and informed consent and some of the, the Saramacca decision. And it's really interesting you discuss Colombia and Brazil. I think what I'd find interesting is to what extent, these decisions will have an impact outside of the American context, in fact, in Asia or in Africa. And that's not so much a question, but just, I think, more an observation as the international bodies pick them up and start to, support or cite the Inter-American Commission and the Inter-American Court. Will they have an effect in India, or will these decisions, the demarcation, the delineation of territory, take place in Asia as well, or to a certain, to the same extent, and then could that have an impact on the environment and other climate change and other aspects as well? So I think there's a lot of interest there, and so it's so interested in hearing, I think, your talk about perhaps at the local level, or the different protocols that are being enacted to ensure those decisions are implemented, because that was something as well that we discussed about it's one thing to get your decision, it's another to get it implemented, and that takes almost as long. Annapurna, I mean, we've collaborated before, and it's so interesting to hear about, I think, the US angles, but yeah, I think I was a little bit interested, perhaps didn't go into it too much, but I was interested in the opposition in the US to, the extent to which there is that opposition to litigating on caste, to, I guess maybe it's not the same kind of opposition if it's litigation, because you already have, it's Cisco who are the opposition rather than, well, I'm sure the various Hindu groups and others in the US as well are watching with interest. So I think there's going to be a really experienced opposition in the UK when working with Annapurna on these issues, and I think it's interesting, I think, to reflect on that as well. So I think that's just a few thoughts. I enjoyed all of the papers, and so yeah, I think we could talk all afternoon, but I'm aware of time. So my last comment is just to thank Federico for bringing us all together here this afternoon.
Oh, really, thank you, David, for organizing this stellar panel of speakers. It's been a pleasure for me to chair. I would like to ask everybody to joining me in thanking warmly David, Aoife, Cathal, and Annapurna for a great panel and a great discussion. I want to thank you all for being with us, and of course a special thank also to Andrew Woolgar from the Brexit Institute for providing technical support to this.